They do. We gotta go to part 2. For business. Yeah. I saw that.
Hello.
That's the little page. Yeah.
Did you bring your book? I have my. Did you bring your book today?
It's,
She wants to staples. You're right. Paper's so nice.
there's the roads. Interesting. Here's the book.
I have a kid, but I guess I'm curious about what's happening. I was talking to Brian. He said
Well, I happen to know he agrees with you. If he doesn't, see here. Okay, so let me just go get the sign-in sheet. Does anyone have the sign-in sheet, or should I go get it? Oh, okay. So like, where's Adrian? Where's Adrian? She's not that silly either. She's really good at it. And it's more like, yes, it is right. It is right.
You just tell us what's on his
It is right there. Semi-retirement is killing me.
Why?
I'm busier than I've ever been.
Keeps you young. Keeps you young.
Yep.
Once you stop moving, that's when it all goes.
It's
I'm
because
I'm in absolutely no danger at the moment.
it's because they think you're available.
Pretty much, yeah. And everyone's like, well, why don't you come into this? Why don't you then? Did I ever come to them before? Yeah, get a clue.
I hear her.
Oh, good, good. Well, this is definitely what she does really well.
Ooh, you guys are gonna be so in for it with your finals for property.
Really?
I'm gonna use plural and singular all night, so that way you never know. You never know. No, it's challenging. All I could say is, now I'm gonna say singular, your exam is a beast. It's challenging. We're impressed by you, so we're going to put you to test.
That's right. Consider it an honor.
Can you not be impressed?
How do we change things?
Hey,
I mean, if you had worn your Ephraim beanie, I might have felt
Oh my
differently,
God.
but you failed.
Is it in the car?
Alright.
Yeah, she's like, we knit one?
It's probably my trunk.
He's like, I'll find it. I'll find something to put on. You failed your class. I don't mean grade wise, you just failed your classmates. All right. So, did you want to start with general statements and then we'll kind of go through some of the approaches?
Yeah, okay, so here we are at the end of real property 1. Huh? Again, theoretically, at least if you sort of start with, future interests outward, this is probably the most difficult class you'll have. So, we seem to be at the end of this semester, and I think you guys are doing really well. And it's not really that hard to tell. It really isn't. I mean, most of it is just generated by your briefs. I mean, if we're doing all the talking, there's a problem. If we're not doing that much talking, that's good. And this session, I've been staring at ceilings and looking up, looking around. Where's my water? Oh, it's fabulous. So gotta be a good class. And so, good job. And I don't really know what else to say at the moment. It's real good this year. Real good class. Yeah.
If it makes you feel any better, everything you need to know for your final in terms of written exams, you like how I did that singular then plural?
Yeah.
I know I'm really trying here. Is contained in these 9 pages. Now this is my bar review outline, so it's a bit more condensed, but everything is in these 9 pages. So all you have to know is 9 pages worth of material for the written exam. For the multi-state, you must know the full semester, okay? Everything is fair game for that. So let's step back though and not freak out for a second, right? How much have we covered since the midterm? And what's our general practice, just so you know, and I think I mentioned this before the midterm, everything between either the start of the class and the exam or the exam and the subsequent exam is what the major issues will focus on. For example, between the midterm and now, we've covered what? Joint tenancy, right? We've covered concurrent estates, landlord and tenant law, and servitudes. Now, under concurrent estates, I'm just going to give you a quick overview and then we'll get into the details. Under concurrent estates, we talked about the different types of tenancies, right? We've got joint tenancy, tenancy by the entirety, tenancy in common, and then we talked about the rights and duties of co-tenants. That's it. That's concurrent estates, okay? Landlord-tenant law, we talked about the 4 leasehold or what we call non-freehold estates. Tenancy for years, periodic tenancy, tenancy at will, tenancy at sufferance. We talked about a tenant's duties and a landlord's duties. That's landlord-tenant law. That's it. Okay, we'll expand on it, but I mean, really, step back and think. I can categorize everything that I need to know in 3 sections and then subcategorize them, okay? The last portion is going to be servitudes. Servitudes broke up into easements, license, profit, covenants, and equitable servitudes. That's it. You know that you've covered all of those. You know that you can write something on all of those. Okay? Now, could you reasonably have multiple easements on an exam? Think back to how we did easements. You could, right? And I said that that's an area that we really like because it's easy to have multiple easements and make you start from the beginning of your story, go through the middle, give me an ending, start again, give me a middle, maybe no ending again, right? So those are really the 3 major areas that we've covered since the midterm. So let's break it down a little bit, okay? Joint tenancies. This is concurrent estates, right? Why is it called concurrent estates? Because people are owning them and having interest in them concurrently. Okay, this is not I'm selling it for me to you, to you, to you. This is a piece of land is being conveyed by Professor Drucker to all of you at the same time, right? So let's talk about one of my favorites, joint tenancy, right? The Brad Pitt, right? The most attractive, right? I don't know, pre-post Angelina, that's a really different story. So the right of survivorship is something that we see when we talk about joint tenancy, right? So what I want you to write when you're talking about a joint tenancy is the right, you want to talk about a joint tenancy with the right of survivorship. Having that language out front, it can be very helpful, okay? Then you know that it is indicative of one of the characteristics of a joint tenancy. Because do you have a right of survivorship with tenancy in common? Everybody should be confident about that answer. No, you don't, right? So the right of survivorship, that's when one joint tenant dies, his share goes automatically to the surviving joint tenant or tenants. A joint tenant's interest is alienable, not divisible, nor descendable. Why? Yes.
It goes horizontal, not vertical. That's how it's transferred.
Why does it go horizontally instead of vertically?
Because that's.
But is that true if it's alienable? So the quick answer is, because of the right of survivorship, it can't be divisible or descendable. It can't go down without a will, it can't go down with a will, but you can sell your interest. Okay? So it's the right of survivorship that really makes this particular concurrent estate unique. So again, it is alienable. Can you sell your interest in the property? Of course. But what happens when you do? Well, let's talk about the 4 unities that are required. So what you want to say when you're talking about a joint tenancy is, in order to create a joint tenancy, joint tenants must take their interest at the same time, by the same title, in identical shares, with the right to possess the whole. And the grantor must clearly state the right of survivorship. So, when we talk about alienability or severance of a joint tenancy, there are different ways that you can sever a joint tenancy, because we just talked about how to create one. Does anybody have any questions about how to create a joint tenancy? Anybody? Okay. So we're good with creating a joint tenancy, but in order to sever a joint tenancy, there's a few different ways you can do that. You can sell some interest in it, you can partition it, or you can present a mortgage. So severance and sale, a joint tenant can sell or transfer his or her interest during their lifetime without the other's knowledge or consent. Now I want to point that out. It's really important that you know it can be without the other's knowledge or consent. Why do you think it's important to distinguish that characteristic in a joint tenancy? Anybody have an idea? Where can you not do it without the other person's?
The tenancy in entirety?
Tenancy by the entirety. Remember, that looks very much like a joint tenancy, but it's reserved only for married couples. And in that one, you cannot do it without the other person's consent or knowledge. So it's really important to identify that characteristic in terms of how you can sever a joint tenancy. One joint tenant sale severs the joint tenancy as to the seller's interest because it disrupts the 4 unities. The new buyer becomes what?
Tenant in common.
You knew that, but you weren't going to say it. No, you didn't know it? Okay, fair enough. Do you know it now?
Yes.
Okay. Why is that? Now I'm going to save that answer for dinner. So 3 joint tenants. 1 sells. They now become a tenant in common. Why is that new buyer a tenant in common rather than a subsequent joint tenant?
Because with purchasing the share, you're not getting the right of survivorship there after that?
Well, you're not, but why? It's a timing issue, is one of the parts. Think about how you create a joint tenancy. What do you need to show? How does it have to be conveyed?
What do you mean, how does it have to be conveyed?
Doesn't it have to be conveyed at the same time to all of the interest holders? Same title,
Right, oh, okay, the 4 units.
identical interest, right? It must have the 4 unities. Because it does not, if one person subsequently sells it to another person, they can't possibly become a joint tenant, right?
Right.
Okay, so in that circumstance then, it creates a tenancy in common for that one person, but the other 2 remaining still have a joint tenancy. Does that make sense? Okay, let me ask it a little bit differently. I'm gonna keep on you for this one.
Okay.
If there are only 2 parties, you and I own this as joint tenants with right of survivorship. I sell my interest to Professor Drucker. He's now a tenant in common. Why?
Because it's the time requirements of,
Okay, because the conveyance did not comport with the 4 unities, right?
Right.
Okay, now let me ask you. He's a tenant in common. What are you?
still a, well, I can't be a joint tenant with anybody, right?
Right.
So, I own it in fee simple?
No, that's not what we're dealing with here.
No.
Well, you can't own the whole property. He owns half, right?
I thought he had no right though.
How does he not have a right? He bought his interest.
I paid good money.
So let's do it one more time. We start as joint tenants with right of survivorship. Professor Drucker,
Just call it Drucker-Riker.
you're taller, okay? That's about as good as my
I have a bigger head
art
too,
gets.
so that makes sense.
His is more narrow. That makes sense. Okay, so you guys own as joint tenants with right of survivorship. He says, I'm tired of this big head tall guy, and I'm going to sell to, I don't know, somebody with like hair. Okay. With like long hair and bangs. That looks like a weird hat. Okay, in any event, he sells to somebody else. That now severs the joint tenancy with right of survivorship. That leaves this person as a, tenant in common. And it leaves you as what? There's only a couple choices. Can you remain a joint tenant?
Not if there isn't another joint tenant, no.
Because there's nobody to survive, right? So what does it naturally default to?
I don't know. The tenant in common?
Right.
I'm a tenant in common
Yeah.
after?
There's no, because you have no right of survivorship with anybody. So a joint tenancy with right of survivorship, if it fails, will default to a tenancy in common. Okay? So now you basically both end up as tenants in common because they don't share the right of survivorship, which means you don't bear the benefit if they die, but they also don't get the benefit if you die. Does that make sense?
Yeah.
But let's revise this a little. Go back to the initial hypothetical. Joint tenancy with right of survivorship. We've got 3 people, okay? Number 3 breaks off, that making them what?
Making 1 and 2 still joint tenants, and then 3 is a tenant in common.
Precisely, okay? The only reason they default to tenants in common when there's only 2 is because there's nobody remaining for a right of survivorship.
So in
Now-
this case, now if 1 or 2 dies, the other one, or.
So let's say 2 dies, okay? Then 1 has a 2/3 interest, right?
Mhm.
And this person still has a 1/3 interest.
And 1.
Now, if this person dies, whoever subsequently takes keeps the 1/3 interest. That's the remaining party there, or whoever inherits or whatever. And this person still retains 2/3. Now, at this point, when this person and this person, or let's even take this person out. Let's say this guy's still alive, number 3, or the person who sold, right? So this is really technically number 4 here, okay? The person that number 3 sold to, let's say number 1 dies. What happens? as a practical matter. There's no more right of survivorship, right?
So does it all go to 4?
No, there's no right of survivorship.
When you go to the heirs.
It would go to the heirs of 1, and number 4 would still keep the 1/3. It continues to go down if there's no right of survivorship. Okay? You wanna do it one more time?
No.
Okay. Because you're gonna be so perfect on the exams?
I have a question.
Yes.
What did the heirs become? Did they become tenants in common then?
Yeah,
Okay.
because there's no right of survivorship. Right? Okay. All right, so now we go into severance and by partition. So this can be severed by way of an agreement. If people decide, okay, we're gonna agree, and I think I gave you my I Love Lucy example, we're gonna agree, we both live in this apartment, but I get my half, you get yours, we're putting a piece of tape down the middle of the apartment. This is by agreement, okay? Now, let's say we don't have an agreement, right? Mom and dad pass away, brother and sister keep the farm, but they can't get along, they can't figure out what to do with it. You can have two ways of severance at that point, or it's 2 ways of partitioning it. You can partition it in kind or do a forced sale. A partition in kind is going to be to split the property evenly into each share, meaning if they had 3 kids, it would be split into thirds. If they had 2, it would be split in half. A partition or by forced sale is going to be where the court gets involved. I mean, the court could get involved in either event. This is really going to be more of a physical division versus a sale and a division of the proceeds. Does that make sense to everybody? So partition in kind is going to be a physical partition of the land. So they're going to put a fence up somewhere and say, this is yours, or do a survey and do the same. A partition by forced sale is going to be where it's basically put up for sale, and whatever money is derived from the sale is then equally divided amongst the parties. Okay? A severance by mortgage, one joint tenant's execution of a mortgage or lien on his or her share will sever the joint tenancy as to the now encumbered share only in a minority of states. This is the title theory. Okay, there is always a multi-state on title theory or lien theory. The majority of states, however, will follow a lien theory of mortgages, whereby a joint tenant's execution of a mortgage on his or her interest will not sever the joint tenancy. So they don't necessarily want somebody mortgaging the property to necessarily sever their interest as a joint tenant in a majority of states. But again, in a minority of states, they will say, if you put a mortgage on your interest in the land, on your piece, on your share, then that's going to sever you out. Okay? And that can affect where the property goes afterwards. So if I'm well, there's pros and cons to it. If I'm a joint tenant that has not mortgaged the property and I am in a lien theory and you have now mortgaged the land, but then you die, that mortgage has now, it gets absorbed into my interest as well. So the property has been mortgaged. Does that make sense? It's a little confusing, but watch this. So, kind of have to have more than 2 people to do that, I suppose. Otherwise, when they die, it's just, well, I guess you don't. Okay, let's say we have 2 people, right? Number 2, oh, that's unfortunate. They put a mortgage on the property, okay? Now, once they put a mortgage on the property, if in fact we are running in a majority of jurisdictions and we're dealing in a lien theory, a lien has been put on the property. So two dies, one absorbs their interest with the right of survivorship, and then the mortgage is still on the property, right? 1 and 2, 2 mortgages the property. This is the other hypothetical. If we are in a title theory state, which is a minority of jurisdictions, once they put the mortgage on, they are now tenants in common. So as number 1 goes, I may not want that because I now don't get the right of survivorship. What I do get, unfortunately, is the mortgage that's remaining. So, depends. Yes.
Do they need their permission?
No. Remember, you don't need to, you can sell or mortgage this without the consent or knowledge of the other party. So there are pros and cons to title versus lien theory. So again, lien theory is going to be in a majority of jurisdictions, and that does not sever the joint tenancy. A title theory will. Okay. 1 page down, 8 to go. We're good. All right. Tenancy by the entirety. What must you have to start?
Spouses, yeah.
Spouses, right? So, between married people, there is a right of survivorship, correct? All right. There must be a marital interest. They used to say between a husband and a wife, but I suppose it's now just a marital interest between 2 spouses. In those states that recognize tenancy by the entirety, it arises presumptively in any conveyance to married partners unless otherwise stated. Does California recognize tenancy by the entirety?
No.
It does not, okay? So it is presumptive in states that do, however. This is a very protected form of co-ownership. Creditors of only one spouse cannot touch the tenancy. Now, that's interesting, and probably why in California they don't honor this kind of tenancy, because we're a community property state. So in the event that you are married and you acquire debt during the course of your marriage, it is the debt of both spouses. You have to show something pretty significant to say that somebody who's married to somebody else, even if the other person, didn't necessarily sign off on it, they're fairly liable for that. Unless there's some kind of fraud or,
Pretty much.
deceit in there. So, unilateral conveyance, neither
Or
gambling,
Debts of,
addiction, yeah.
Yeah, debts of, what do they call it? Oh, debts of this dispute, that's what they used to call it, it's a more newer name. But like, for instance, if your spouse runs up a gambling debt, you're not responsible for it under community property.
Didn't benefit the community.
Yeah, it's never of a benefit to a community to do acts that are illegal in California. So even though it might be legal to do, go to Las Vegas, it's not legal here. So when they come to break your legs, you might tell them that. But this is California, homie.
So now this is where we run the difference between the joint tenancy with right of survivorship. Aside from the marital union that must be shown, we also have a circumstance where unilateral conveyance, neither tenant acting alone can defeat the right of survivorship by unilateral transfer to a third party. The example I gave you here was, daddy's sweet little girl and step monster, right? Dad and stepmom are married. Dad doesn't want to tell his new wife that he's leaving his interest to his daughter. And he tells her, you're going to get this. He wills it to her, and stepmommy walks in and says, not on my watch. I didn't consent to that. And guess what? This is a state that recognizes tenancy by the entirety. So I'm sure your father meant well, and I wish you the best. Leave my house, right? Make a plate on your way out. I'll see you later, or not so much. Okay, so everybody good with tenancy by the entirety? Now the favorite and the default, right? Tenant in common. So important features of this, each co-tenant owns an individual part and each has a right to possess the whole. So even if you only own a half interest in the land, you still have a right to possess the whole. Each interest is descendable, divisible, and alienable. Why?
Because there's no right of survivorship.
Yes, precisely. The presumption favors tenancy in common. So if there is no language or action to support a right of survivorship, or there's some question about the 4 unities, it is presumptively going to be a tenancy in common. So in a circumstance where you have an exam and you are discussing a tenancy by the entirety or a joint tenancy, and it fails, what will you also discuss? Tenant in common, right? Okay. So those are the 3 that we have in terms of concurrent estates. Now we shift to another area underneath concurrent estates, and that is the rights and duties of co-tenants. So now we're away from what their interest is. Now we talk about what their rights and duties are as interest holders. Each co-tenant is entitled to enjoy the whole. If co-tenant wrongfully excludes another co-tenant from possession of the whole or any part, he has committed a wrongful ouster. Rent from co-tenants in exclusive possession. Absent ouster, a co-tenant in exclusive possession is not liable to the other for rent. What does that mean? That means if 3 of us in the room own a property together as co-tenants, and I live on the property and y'all have your own place to live, I don't have to pay you rent for living on the property that I have a right to possess as a whole, right? Just like you wouldn't owe me rent if you lived on the property. Now, let's distinguish that from us renting to a third party that is not one of the co-tenants. In that case, the person collecting the rents must distribute equally amongst the co-tenants. It's all okay if you want to stay on your own property. The second you start charging somebody else to stay on it, now you got to divvy up the proceeds, okay? Adverse possession. You cannot adversely possess as a co-tenant with the exception of being wrongfully ousted. If you then adversely possess, you are doing so in a hostile manner, right? You still have to meet the other elements of adverse possession, but you cannot have an adverse possession with co-tenants without a wrongful ouster having been shown. Otherwise, they have an interest to possess the whole. They can't possess it in a hostile manner, because that would be without the consent of the owner. Okay?
And let me throw something in there, because you see this on the bar, actually, from time to time. So we have co-tenants, right? We have 2 tenants of one property, and one moves away. He or she doesn't want to live there, so they just leave. Once they're gone, the tenant that remains puts up a fence and puts out a sign that says, all co-tenants shot on site. Okay, is that a good wrongful ouster for purposes of later trying to claim adverse possession? Yes or no? What do you think? And just common sense tells you yes or no.
I would say yeah.
You say yes.
It's a physical ouster, right?
Okay, that's good, but there's 2 elements, not just one.
It's made,
Okay,
they're
and
made,
one is a physical ouster. Well, what would be the other one?
they're made aware of it.
They have to know. In that analysis that I just gave you, does the other party know? No.
Until they get
So
back.
will that be a valid ouster? The answer is no. They have to know they're being ousted. It has to be, what's that word?
Apparent.
Okay, what else?
No.
If they don't know, how can it be
Um,
hostile? There you go. Good job. Good job. All right, I can see you all being in court one day and saying, I think I'm gonna have co-counsel answer this one. There you go. Good job.
So the other area, if you can accept your fair share of the rents, if there is a third party renting, don't you also have to give your fair share of the carrying costs? The answer is yes. So each co-tenant is responsible for his or her fair share of carrying costs, such as taxes and mortgage interest payments based on their undivided share. So if I own a quarter interest, I owe a quarter of the carrying costs. Repairs. The repairing co-tenant enjoys a right to contribution for necessary and reasonable repairs provided that he or she told the others of the need. The other co-tenant must contribute the percentage that reflects their share. No, you'll notice I said contributions for necessary and reasonable repairs that the others are notified about. This is not just upgrades that the person wants to make. These are necessary and reasonable repairs, okay? Now, for example, let's say a pipe bursts and they have to go and, you know, repair the piping and then repair the drywall that was damaged and paint and do all of that. Are those necessary and reasonable? Yeah, because you don't want the house to flood, right? So those would be reasonable and necessary, but what you should do is call the other people and say, hey, I gotta get somebody in here, here's the circumstance. And then obviously you don't get the most expensive person you can ever find to do the deal, you find somebody that's reasonable. Now, if the only person you can find, because it's an emergency, is very expensive, that's just what you deal with, okay? Improvements now, let's distinguish repairs from improvements. During the life of the co-tenancy, there is no right to contribution for improvements. At partition, however, the improving co-tenant is entitled to credit equal to any increase in value caused by their efforts. The so-called improver also bears full liability for any drop in value caused by their efforts. Okay? Now, we also get into the issue of waste. How many types of waste?
3.
What are they?
Ameliorative.
Nice that he started with that one, okay? Which means what?
I don't remember, sorry.
Anyone wanna help?
It's
Ameliorative cannot make changes to property without consent. They economically benefit the property, but they cannot diminish the market value.
So ameliorative waste is when you do something to the property that increases the value, right? So you haven't necessarily damaged the property and it increased the value, but it was done without the consent of the other party. Now, permissive waste is kind of you just not taking care of things, right? Voluntary waste is when you actually take an affirmative action. So voluntary is the same as affirmative. Permissive is really, you know, you're just not taking any action.
Didn't do something. It's do something versus didn't do something. The classic is, okay, you buy a house and then you're the person who's the tenant, and then you know you're in a storm zone, the storm comes and you forget to put up the storm windows. Okay, and then there's damage to the house, right? Okay, which one is that?
Permissive,
Why?
because you didn't
You failed to act.
feel that, yeah.
Okay,
So
it's do something versus not do something. Right, there you go.
the only other thing I would say under rights and duties of co-tenants is that a co-tenant does have the right to bring an action in partition to sever the co-tenancy, okay? And we talked about those different types of severance and partition. So that's joint tenancies, that's concurrent estates. Okay? 1/3 down, right? Look, 37 minutes in, you're 1/3 down, okay? Everybody? Okay, we're going. All right, now we get into our second section. Our second section is going to be that of landlord-tenant law. This is a heavily tested area on the bar exam, probably the most heavily tested area on the bar exam when it comes to real property.
Well, in fact, it's the most
Uh-huh.
tested subject on the bar of all time. It's actually landlord tenant. That's true.
Mhm.
So good good chance you're gonna get a landlord-tenant question if you get, your odds, actually, they said your odds are better than 50-50. If you have a real property question on the bar, that it'll be landlord-tenant. That's how often it's tested. Because why? Because students always get it wrong. Always.
And it's a very straightforward area.
It's really straightforward.
You start getting in your own head though,
Yeah.
okay? So, we have four leasehold or non-freehold estates. The first of which is a tenancy for years. This is a lease for a fixed period of time. When you know the termination date from the start, you have the tenancy for years. I think this is the week I was gone, because I don't remember saying this to you guys before. But I know it was discussed when we went through the cases. So, let me just say this. If you know at the start of the lease when it will end, chances are it's a tenancy for years. Does it have to actually be years long? No, it's a bit of a misnomer, right? Can it be for 6 months? Yes, it can be. You just have to know the duration of the lease. Now, let me ask you this. If I say beginning January 1st, 2019 for 1 year, have I given you an expiration date? Why?
You said for 1 year.
So it would naturally end December 31st of 2019, right? Right. You don't actually have to see the date printed. It just has to tell you, unambiguously when it would end, okay? So a tenancy for years, the lease is for a fixed period of time. And you also know from the start when the termination will occur. Because it's a term for years and it's stated at the outset when it will terminate, no notice is needed to terminate it. It naturally expires. So if I have a lease for 1 year, beginning January 1st, 2019, must I give notice to my landlord that I am not renewing? No, not unless there's some other term written in. A term of years greater than 1 year must be in writing to be enforceable to satisfy what? Statute of frauds. You guys think it's gonna go away in contracts after you're done, right? It comes back over and over and over again. So again, if it's for more than 1 year, you must have it in writing to satisfy the statute of frauds. That is a tenancy for years. Again, that is very identifiable. It's for a fixed duration. At the outset, you know what the expiration is. There is no notice requirement to end it. And if it's more than 1 year, you must have it in writing to satisfy the statute of frauds. Those are all the characteristics of a tenancy for years. Distinguished from a periodic tenancy. This is a lease which continues for successive intervals until the landlord or tenant gives proper notice to terminate. Now, a periodic tenancy can be both created in writing or it may arise by implication in any of these 3 ways. The land is leased with no mention of duration, but provision is made for the payment of rent at set intervals. Okay, so rent is due on the 1st of every month, but they don't say it's for 1 year. They just say, you're leasing this now and your rent is due at the beginning of each month. Those are 30-day successive intervals, right? An oral term of years is in violation of the statute of frauds, creates an implied periodic tenancy measured by the way rent is tendered. So again, let me say that. An oral term of years in violation of statute of frauds creates an implied periodic tenancy measured by the way rent is tendered. For example, if you have a tenancy for 1 year at a time, then you pay at the beginning of each year. The holdover is in a residential lease, if landlord elects to hold over a tenant who has wrongfully stayed past the conclusion of the original lease, an implied periodic tenancy arises measured by the way rent is now tendered. For example, let's say you start with a tenancy for years. Let's say your hypothetical is tenancy for years, right? It's for a 1-year period, January 1, 2019 through December 31st, 2019, or we just say starting January 1st, 2019 for 1 year. But I decide to stay on property into January 2020. What are you going to do in terms, and then I keep paying rent on the 1st of every month. What analysis are you going to do on that exam? What are you going to start with?
Tenancy for years.
Tenancy for years, because we have a fixed duration. We know at the outset what the expiration date is. No notice is required to end it, but now we've got a holdover. So we conclude, here's the tenancy for years, right? Did it have to be in writing? No, because it didn't exceed 1 year. But now we go into the next issue analysis, right? Now we've got somebody who's holding over past the 1 year expiration, but they're paying rent on the 1st of every month. So now we have our successive intervals. We are measuring it by the timing of payments of rent. So these are successive 30-day periodic tenancies. Now that's very important to note because we have to talk about how do you terminate a periodic tenancy. Usually written notice must be given. If you're ever advising a client, written notice must be given. Why? What do you think is going to happen if written notice isn't given?
They're going to assume the periodic tenancy is continuing.
Well, if I'm the landlord, I'm just going to say, okay, where's my rent now for the next month? Right? And if they go to court and they say, no, I wasn't going to pay it for the next month, and the person's going to say, well, you never gave me notice about it. Yes, I did. No, I didn't. Yes, I did. No, I didn't. You see what we get into? Write the note. Okay? And
well, there's another reason for that. Why? Because under that scenario, you at the landlord are going to lose. Why? I can tell you flat out you're going to lose. I don't even care what you say. There's a hint. Could care less what you say. Because it's a transaction in land and it needs what?
It's right in.
Because statute of frauds never goes away. Never. Not, certainly not in real property law. It's always there working in the background.
so now here's the other thing you need to be cognizant of. Not only must you advise people to do this in writing, notice must be equal or at least equal to the length of period itself unless otherwise agreed upon. Now, I always do this. Let's see how many of you jump on this properly. 30-day periodic tenancy, how much notice must you give me? 60-day periodic tenancy, how much notice must you give me? 90-day, how much notice must you give me? 120, how much must you give me? Okay, 150. Anybody? How much notice must you give me? 150. 180, how much must you give me? 1 year, how much must you give me?
A year. Jeez.
Okay, let me ask you this, 210, how much must you give me?
210.
No. 180. You max out at 6 months.
Oh.
Okay? Up to 6 months. That is the maximum. Okay? So any periodic tenancy that is greater than 6 months only requires a 6-month notice. Anything less than requires notice equal to the length of the periodic tenancy. Unless, of course, there's another agreement made.
Right, other right of the change.
By private agreement, the parties may lengthen or shorten these common law prescribed notice provisions, okay? So if we have agreed in writing that I must give you a year notice, let's say it's a 5-year lease, right? And we say you must give 1 year notice, and that's what's written. You can deviate from the common law rule. All right. All right, we've only got 6 more pages after this, okay? We're more than a third of the way done with our review. Let me say it that way.
So far, you're knocking the ball out of the park, right? No matter what you get.
So, the tenancy at will. This is a tenancy with no fixed duration. Anybody ever been hired as an employee or an at-will employee? Do you guys know what an at-will employee is?
California's an at-will state, isn't it?
So I can hire you, I can fire you at any time, unless you have an employment contract of some sort.
Or if you do something against public policy.
Right. So think of this as the same kind of circumstance. In this case, we are also dealing with something that has no fixed duration. Unless the parties expressly agree to a tenancy at will, the payment of regular rent will cause a court to treat this as an implied periodic tenancy. Why? What don't they want people doing? They don't want a landlord showing up and saying, get out. When? In 30 days? In the term of the rent? No. Now, pack your stuff, let's go. We also have other laws that cover that, but when we're looking at this just in its ivory tower, that's what we are trying to prevent. The tenancy at will may be terminated by either party at any time. However, a reasonable demand to vacate is usually required. You can't just show up at 8 o'clock one night and say, knock on your door, I don't like you anymore, I want you out, my niece is gonna come move in here instead, and she needs to be here tomorrow, leave. Cannot do that, okay? So tenancy at will is pretty easy. Not commonly used, has to really be expressly stated, and you have to give reasonable notice. And it's available to both landlord and tenant, okay? This is not just driven by landlord right. Then we have a tenancy at sufferance. It's created when the tenant has wrongfully held over past the expiration of the lease. We give this wrongdoer a leasehold estate called the tenancy at sufferance to permit landlords to recover rent. The tenancy at sufferance lasts only until the landlord either evicts the tenant or decides to hold them to a new tenancy. What kind of new tenancy do you think they would naturally hold them to? Implied periodic tenancy, absolutely. Okay, now we get into the tenant's duties. Tenant's liability to a third party. Tenant is responsible for keeping premises in reasonably good repair. Okay, you just kind of have to keep things moving along as they are. Tenant is liable for injuries sustained by a third party that tenant has invited, even where landlord has promised to make repairs. Now that's a little frustrating, but true.
Well, kind of, and it has to be too. I mean, it's strange because I actually, a long time ago, had a case on that. And, you know, the tenant had a party, and the tenant knew that only the hot water worked in one of the sinks. And he invited all these people over, and so one of his guests, and he told the landlord, but the landlord wasn't, he just didn't get around to it. He said, yeah, I'll get on it, and it was only a couple of days or something like that, so it wasn't that bad. But he had this party over the weekend, and one of his guests put his hands under the water and he burned his hands. He got like second-degree burns. So who would you hold liable under that one? The landlord or the tenant? Think about it. What do the equities kind of tell you on that one? Well, if I'm his client, both, but what do the equities tell you? Who would you hold liable for that? I hold the tenant, wouldn't you? I mean, they knew about it, they could have put up a sign and said, don't use the faucet. But I mean, if you think about it as a practical matter, also society kind of demands that, because who's in the better position to protect the public at large in that situation? Tenant's in way better position, right? So you don't want to give the tenant a pass on those things, right? Okay.
So tenant's duties to repair when the lease is silent. Tenant must maintain the premises and make ordinary repairs. Tenant must also not commit waste. Again, we have those 3 types of waste. We have voluntary where this is some overt or harmful act, permissive where you are essentially neglecting the property, and ameliorative where the alterations can increase value of the property. The law of fixtures also walks hand in hand with waste. When a tenant removes fixtures, right, they commit voluntary waste. A fixture is a once movable chattel. By virtue of its annexation to the realty, objectively shows the intent to permanently improve the realty. A furnace, custom storm windows, heating system, those would all be things that would be presumptively fixtures. The tenant must not remove the fixture, no matter that she installed it. Fixtures pass with the ownership of the land. So, I know you're looking at me like we can't ever fix anything and then take it with us. That doesn't make sense, right? Okay, let's talk about that. When installation qualifies as a fixture, express agreement controls any agreement between landlord and tenant on point is binding. In the absence of an agreement, tenant may remove the chattel that he or she installed so long as removal does not cause substantial harm to the premises. Okay? So if you put up a beautiful chandelier and you decide that you're going to be leaving with that because it's some kind of heirloom, as long as you can reasonably remove it and not cause substantial harm to the premises, then it does not qualify as a chattel. I'm sorry, it does not qualify as a fixture. It is still a chattel. If removal will cause substantial damage, then in objective judgment, tenant has shown their intent to install a fixture and the fixture must stay. From that perspective, once you affix it in such a way that it would cause significant damage, it has now been affixed to the land and should pass with the land, okay? Tenant's duties to repair when tenant has expressly covenanted in the lease to maintain that property in good condition for the duration of the lease. Common law is that tenant will be liable for any loss to the property, including loss due to the force of nature. Majority view, however, the tenant may terminate the lease if the premises are destroyed without tenant's faults, or without tenant's fault.
Again, another contract concept, what's that called? Got it. The land's destroyed. No follow the tenant, what does that sound like?
Oh, that's really It's not frustration of purpose,
Close?
no, it's one of those 3.
Yes, one of the big 3. I'm not telling you what they are. It's contract law.
One of them starts with an I.
Impossibility.
Hey, impossibility, it's just a contract. Very good. There you go. Don't forget your contract on these. Real property, it helps.
Leases are contracts, guys.
That's all they are. Yeah, just
Okay.
contract for renting of land.
So, tenant's duty to pay rent is independent of any other duty or right for that matter. So the tenant breaches this duty and if the tenant breaches this duty and is in possession of the property, this is how you're going to break down tenant's duty to pay rent. Are they still in possession of the property? Are they out of possession of the property? If they are in possession, landlord's only option is to evict through the court or continue with the relationship and sue for the rent due. If the landlord moves to evict, she is nonetheless entitled to the rent from the tenant until the tenant, who is now a tenant at sufferance, vacates. Okay? Landlord must not engage in self-help. What does self-help look like? Changing the locks, throwing them out, physical removal, removing of the party's possessions, right? You can't treat this like they're getting bounced from a bar, okay? All right. Tenant breaches this duty but is out of possession. You can treat it as a surrender. Landlord could choose to treat tenant's abandonment as an implicit offer of surrender, which the landlord then accepts. If they do that, tenant shows by words or actions that she wants to leave or give up the lease. If the unexpired term is greater than 1 year, what do you think the surrender requires?
Right.
Written notice, absolutely, to satisfy what? Statute of frauds. The landlord could ignore the circumstance. Landlord could ignore the abandonment and hold tenant responsible for the unpaid rent just as if tenant was still there. This is a minority view, okay? What is the majority view? That you have to relet the apartment. Why? Because you have to try and mitigate your damages. So landlord may relet the premises on the wrongdoer's tenant's behalf and hold him or her liable for any deficiency. What does that mean? That means you must try and rent the property again, and if there is any deficiency from what you would have made from that original lease, then the previous tenant is still on the hook for that. For example, let's say it's the middle of or beginning of summer in the desert. Do you think that the person is going to be able to rent it, a location, for the same amount that they may have otherwise been able to rent it for in October? No, they're not. So what are you going to do in that case? You're going to rent it for as much as you can, and whatever you are lacking, you're going to pick up from the previous tenant who burned you. Now, if you get equal or more than what the contract was for, do you have any recovery from the previous tenant? No, because there is no deficiency. Okay? What circumstance do we see if somebody is renting for the same amount, but there is a gap of 2 months? Let's say it took them 2 months to get somebody new in there.
Depends on how hard they tried, right?
No.
To get somebody in there.
Mm-mm. They make reasonable efforts.
It's on the landlord. I remember you drawing all those different figures.
Well, it depends, right? It depends on how much they recover for those. Let's say there's 6 months remaining on the lease. Let's say it's $1,000 a month, but there's 2 months where they don't get rent and they only get equal to what they would have before of $1,000 for the other 4 months. What can they recover?
2 months rent.
$2,000. Let's say, however, they end up getting $1,500 for the remaining 4 months. I know it's a lot of math I'm gonna make you do right now. How much do they recover on the balance of the 6 months?
The remaining rent minus what they got,
It's the same amount.
right?
It's the same amount.
Really?
15 times 4 is 6.
Oh, okay.
Okay, so they recover nothing. Now, does the previous tenant get some kind of payback if they end up getting way more money? Nope. They should just be thanking their lucky stars they're not on the hook for any additional funding, right? So, all right, we're down to like 4 1/3 pages, okay? We're cooking. All right. And if you'd like, what we can do is we can just go straight through if you guys would like to have a little bit more time to study or do whatever you need to do. Unless you prefer to take a break. No? Okay. All right, so now let's go into landlord's duties, okay? Now, what's the first thing you have to do as a landlord to a new tenant or for a new tenant? As a practical matter, what's the first thing you have to do?
Deliver possession.
Deliver possession, right? We have 2 rules. One's called the English rule, one's called the American rule. Interestingly, which rule do you think we use here? The English rule, right? So the English rule says it requires the landlord to put the tenant in physical possession of the premises. Thus, If at the start of tenant's lease, a prior holdover tenant is still in possession, landlord has breached the new tenant and the new tenant gets damages. In a minority of jurisdictions that follow the American rule, landlord does not have to put the tenant in physical possession, they only have to put them in legal possession. Meaning that tenant now legally has an interest in possession of the property, so they can effectively give them the key and say, good luck. Okay? You have an interest because you signed a contract with me, I don't have to do anything else. That's not how we operate. Why? Because as a practical matter, tenant 2 is not in privity of contract with tenant 1. Right? Do they have any legal action they can take? Not necessarily. Who can? Landlord, right? Landlord can go and evict them. Can tenant 2 evict tenant 1? No. So that causes us to say in a majority of jurisdictions, landlord is the one that should make sure this is taken care of, not tenant, okay? Now we get into the implied covenant of quiet enjoyment. What does that say? It applies to both residential and commercial. Tenant has a right to quiet use and enjoyment without the interference from landlord. Breach can be by wrongful eviction. This occurs when landlord wrongfully evicts tenant or excludes tenant from the premises. Okay, we have two kinds of eviction, all right? We have an actual physical eviction. That's where you actually remove the tenant from the property illegally. Well, it doesn't have to be illegally. I'm sorry, I shouldn't have said that. You actually physically remove the party from the property. Now, that should be, I guess it is wrongful, so it would be illegally. So you lock them out, you throw them out, you throw all their stuff out, don't allow access. But you can also exclude them from the premises constructively. So this is what we call a constructive eviction. And in order to support a constructive eviction, you must sting. Okay? There are 3 elements to show a constructive eviction. And when you're writing this on an exam, this would be landlord-tenant, right? You'd go through what kind of lease they have. Then you'd go into landlord's duties. You'd put a subheader in for implied covenant of quiet enjoyment. And then underneath that, you're going to talk about a constructive eviction. So constructive eviction, you must sing, right? There must be a substantial interference. You must, landlord's actions or failure to act have caused a substantial interference. Tenant must notify landlord of the promise, so there must be notice, and landlord must fail to act meaningfully, and tenant must then get out, or what we call vacate, okay? S-I-N-G. Substantial interference due to landlord's actions or failure to act. Notice must be given, tenant must notify landlord of the problem, landlord must fail to act meaningfully, and the tenant must actually leave. They must vacate within a reasonable time after landlord fails to correct the problem. Now, can you say it's a constructive eviction if you never tell your landlord? Why?
There's no notice.
Because it's a required element. Can you be constructively evicted if you notify them and then leave the next day? No, because you have to give the landlord reasonable time to act. You have to show that there's been a failure to act on their part, okay? All right. So now we get into a separate subject of implied warranty of habitability. This is still under landlord's duties. Does the implied warranty of habitability apply both to residential and commercial?
No.
Does the implied covenant of quiet enjoyment apply to both residential and commercial?
Yes.
Yes. Why not the implied covenant of habitability? Or implied warranty of habitability?
Because, you're not, commercial isn't meant for habitation.
Right, commercial is not meant for you to reside in. So, is the implied warranty of habitability that is only applicable to residential facilities waivable?
Sorry, can you do that one more time?
Is an implied warranty of habitability that only applies to residential facilities waivable?
Yes.
Why?
I'm confused by the question. Are you talking about in regards to a commercial
No,
piece of property or?
an implied warranty of habitability is not applicable to commercial, correct? So it's a residential property. Is it waivable
By who?
by either party? I mean, really, it's for the tenant. Is it waivable? Can you waive an implied warranty of habitability if you're a tenant?
I don't think so probably because of public policy reasons, because we want to promote sanitation and.
Precisely.
Okay.
If you were purchasing the property, would it be different?
Yeah, because you can do what you want with your property.
You can buy a hole in the wall. I mean, you can buy a hole in the dirt, right? You can buy a sinkhole if you wanted to, but you can't rent one out. Okay? So it's not waivable. The premises must be fit for human habitation. Okay? How do we look at that standard? That standard may be applied by the local housing code or case law. Habitability issues that are commonly triggered can be things like no heat, no air conditioning, no plumbing, no running water, because those are things that would negatively impact the health and welfare of the parties living there. The tenant's entitlements when the implied warranty of habitability have been breached are 4 different options. They can move out and end the lease. They can repair and deduct the amount of the repair, reasonable repair, from the future rent. And this is allowable by statute in some states. They can reduce their rent and withhold all the rent until the court determines the fair rental value. Okay? However, where does the money go in the interim? Escrow. Yeah, absolutely. Because what's going to happen at the end of the 3 months or 4 months or 6 months or 9 months that it takes to resolve this? You think that the tenant is going to have saved all that money and have it right there to go pay the necessary amounts to the landlord? Probably not, right? Especially if it's over the holidays. I've got a little free with the Lakers tickets and with all the gifts that I'm buying, Gucci bags, all the stuff, right? Okay. I had to replace my credit card because somebody bought 2 pairs of men's Gucci shoes. Most heinous things I've ever seen in my entire life. So heinous, in fact, that Nordstrom called me and said, "This is so in contrast to what you would normally purchase that we think it's fraud." And I said, "Well, you're absolutely right. Those $900 pair of Gucci men's sneakers that look terrible are in fact not for me." Yeah. Mm-hmm. So.
Gotta be those orange ones.
No, they were white and they looked like shape ups. They were weird. So, all right, you know what I'm saying? Like the last option here, though, if the tenant's entitlement when the implied warranty of habitability is breached, they can remain in possession and pay rent affirmatively and then seek money damages. Okay? That's going to be the cleanest way to do that. Why? Because you can show a track that you've paid all the money and then you just sue them for what they owe you. At least then you know they have some money, right? So again, you can move out and end the lease. You can repair and deduct. You can reduce your rent and withhold the rent in escrow until it's sorted out, until the court makes a determination of the fair rental value. Or you go ahead and remain in possession, pay rent affirmatively, and sue as a separate action for your damages. Now, we've got actual eviction, we've got constructive eviction. We also have retaliatory eviction. What is that? That's when a tenant reports lawfully to the housing code. Sorry, let me start that again. If tenant lawfully reports landlord for housing code violations, landlord is barred from penalizing tenant by raising rents, ending the lease, harassing the tenant, or any other reprisals. Now, we talked about this a little bit. There's kind of a, I don't know if it's so unspoken, I think it's spoken in some states, but there's about a 90-day window where if your tenant has made any allegations or any lawful housing code violations notifications to the housing board, you cannot engage in any of those things against them as a result, okay? It will absolutely, during that 90-day window, look like you are committing a retaliatory eviction, okay? Does that mean at day 91 you should do it? No, ease it out. Now, let me just say this. What if you are a landlord and the lease says at the first of the year, every year, your rent will go up by 3%? Can you still do that if it's within the 90-day window?
Yes.
Yes. I mean, I think that that's pretty fair considering the contract was likely signed well before and not during the time frame that it would be viewed in retaliation for the notification. Likely it would have completely predated any notification. So I think you could reasonably say one is independent of the other, okay? So assignments and subleases. I'm gonna just kind of break this down pretty quickly. Assignments, well, let me just ask, can somebody distinguish for me an assignment versus a sublease?
You're talking about assigning a lease, that's what you're talking about?
Uh-huh.
Getting the lease assigned, so it's just like an assignment.
An assignment versus a sublease.
So an assignment, you're bound still by the terms of the original lease.
Who is?
The other tenant, the person that's taking possession of the
What
property.
are they called?
The assignee,
Yes. What is the person who is assigning it to them called?
the assignor.
There you go. Okay. Sometimes we forget. We gotta take a step back and go, I don't remember what they're called. Two?
So they're
Okay.
bound by the original terms of the original lease, where the sublease, the sublessee is not bound because
Don't they still have some obligation?
they have obligations to pay to the sublessor, but not the original.
Well, let me ask you this. As an assignee, aren't you also given all the rights of the assignor? It's not just obligations, right? So the way you can distinguish this is when there's an assignment, all the rights and obligations of the assignor is transferred. A sublease is going to give them something less. Does that make sense?
Yeah.
Okay. Now, in an assignment, at that point, landlord and tenant two, or the assignee, are effectively in privity of contract and privity of estate. Okay? In a sublease, tenant two and landlord are not in privity of contract, right? Because landlord and tenant are the ones that contracted together, and tenant one and tenant two have an agreement. Okay? Does that make sense to everybody?
Yeah.
That's assignments and subleases. Okay? I'm not gonna make you guys bleed over that one. All right? Just know, if there's anything less than full transfer of all the rights and obligations of tenant one, then the assignee is not taking an assignment. They are instead a sublessee. Yes?
So this is the one where you use the language that the assignee steps into the shoes? Or no?
You could. I mean, that would effectively be what they're doing.
Okay.
They kind of do, but the one difference, I mean, it depends on the area.
And it'll distinguish it in the question, right? Like anything less.
Oh, yeah, they'll tell you. I mean, the classic is they'll say the classic bar question says tenant one assigned
Oh.
to tenant two, but tenant one kept 1 day so that they would come back on the last day. There's actually, so they could come back on the last day of the assignment. Is that which one's that? That's actually a question on the bar. Think about it.
So you held on to it for an extra day? Is that what you're
You
saying?
reserved the right to come back on the last day of the lease. Oh, no, let me draw it out for you real quick. I can show you how it works. I mean, if you think is that a practice? Excuse me.
Mm-hmm.
I'll borrow your pen now.
Mm-hmm.
Good. Yeah. Okay. Here we have, again, it sort of helps to draw this out, right? Okay, here we have landlord to T1. Okay, here's their lease, right? Okay, then T1, and they'll say it too, they try to fool you. It's a hint where we're going. Assigns the remainder of the lease to tenant 2, but when they assign it, they reserve, tenant 1 reserves the right to come back on the last day and take control of the lease. So, is that an assignment or a sublease?
A sublease,
Why?
because it's something less.
Something less than total. An assignment must be total rights, otherwise it's not. Because what happens with, in this situation, is as a practical matter, and it's, you don't want to get too crazy about it, but it's a question of, and what makes it a little, like when you ask the question, I kind of went, well, it depends what part of the law you're in, but it really does. But the thing is as a practical matter then, is that the reason why landlord wants this to be an assignment, okay, is because that makes T1 and T2 liable. They're both liable. I mean, T1 doesn't go away. They're still liable, right? But in a sublease, the only redress that landlord has is to go to tenant 1. Tenant 2 is not in privity with landlord. Got it? Right? Their rights, T2's rights still rely on tenant 1. So that's why landlords don't like subleases, by the way, in case you ever wondered about that. So, all right, we good? So that makes sense if you think about it, right? But anyways, right. Good job.
All right, so now let's get into landlord's tort liability, okay? Everybody wake up. Okay, gotta keep it going. Getting the important stuff.
This is
Right.
really important, by the way. I mean, if you're gonna do this law in real life, this is hot law right now. Like smoking or like smocking. Had to do it, sorry.
So let's say, what's the common law? Common law is caveat lessee, let the tenant beware, landlord is under no duty to make your premises safe. They have to make them habitable, they don't have to make them safe, okay? Habitable is just so that it meets the basic standard human habitation needs, okay? So, are there exceptions to the common law? And again, when you're writing this on an exam, you're first going to give me the common law rule, right, or the general rule, then you say there are exceptions to it, if there are, right? If you start with the exceptions, how am I supposed to know what they're an exception to? Does that make sense? Okay, so the answer is yes, there are exceptions to the common law. The first is going to be, most notably, common areas. Landlord must maintain all common areas, hallways, stairwells, for example. Let's say an apartment building. you know, who's gonna be responsible for the stairwell? Right? The landlord. Otherwise, you know, it wouldn't really be managed. Latent defects. Why? Because a landlord must warn the tenant of all hidden or latent defects that landlord knows or should know about. Because if they're latent defects, tenant's not gonna know about them, right? Now we get into this idea of assumption of repairs. This is kind of a quirky one. Landlord who voluntarily makes repairs must complete them with reasonable care. So what are you gonna get? You're gonna get your landlord who's gonna go and say, I can manage fixing those stairs. And they're gonna go in and put a couple nails in, put a little,
Slumlord.
well, no, they probably just wouldn't do anything.
Slumlords wouldn't even put in the nails.
So they're gonna go in, that's gonna be more of a habitability issue probably. So they're gonna go in, they're gonna make some shoddy repair, because you know, they've got a sweet set of tools at home. And turns out they're not structurally sound, and those stairs then collapse. Got a real problem then, right? Who's liable? Not the tenant, okay? Now, the next one we have is public use exception. A landlord who leases public space, now this is really, you wanna put your head in the idea of a convention center, some kind of hall, a museum, right? Think of some kind of gala happening or a wedding, right? Landlord who leases public space and who should know because of the nature of the defect and the length of the lease that tenant will not repair is liable for any defects on the premises. I think I gave you the example. When I got married, we got married at Rancho Las Palmas, and we were in their grand ballroom. And do you think that if one of the outlets was malfunctioning, that I should be responsible for fixing that? No. Why? Because the length of the lease and the type of repair would not suggest that the people who are using or renting it for public use would be responsible for that. Who should be? Rancho Las Palmas, right? Okay. Then we've got this last exception, short-term lease of a furnished dwelling. I always think of the divorcee apartment, right? Anybody ever see, what was that movie, Under the Tuscan Sun?
Oh yeah, I saw that.
Right? Okay, so this lady gets divorced, she moves out of her house, she takes like a coffee cup or something, like, gives the guy everything, she's like, I just don't want anything. Okay. She leaves and she goes and rents out this furnished like studio apartment. Is she responsible for the repairs in that furnished studio apartment? No, because it's meant to be for short-term lease. Let me give you a better example. Not technically a hotel, but what if you go rent an Airbnb for a week?
That's actually a good example. It's a really interesting one.
Exam next time. Exam next time.
Oh, yeah, for sure. That's a lot, and this is
Maybe
really
this
hot
time.
right now.
Okay, so Airbnb, right? So we've got common area, latent defects, assumption of repairs, public use, and short-term lease of furnished dwelling. Those are the exceptions to the common law rule that tenant or that landlord is under no duty to make the premises safe, okay? That falls under the category of landlord tort liability. Okay, now we get into the good stuff, all right? Servitudes, okay? You know I love me some easements. Let me just repeat, you know I love me some easements, okay? Okay, again, we can get a lot packed in, and I'm just saying if Professor Drucker was feeling particularly sassy, he could even make me think a question could be challenging, okay? All right, now let me get, anybody want to take a stretch for a minute before we get started on easements and servitudes? I'll stand up, take a deep breath. Anybody have gum? No? Do you have enough to share with the whole class?
You guys split it in half?
I
have three.
All right, everybody take a piece of gum, unless you have some bridge work or something that prevents you from doing so. You can't have gum? Okay.
I have a copy.
Then take a stand up for a second, take a deep breath. You don't have to eat any gum if it's gonna affect your teeth. Stand up, take a deep breath when she moves. Move around. Oh, I'm fine, thank you. I don't want to do that while I'm talking. Court reporter saved that. But why do I want everybody to chew a piece of gum? Well, you definitely need 2 pieces. All right. So the reason I say this and why you should do this during any exam that you have is because when you're chewing gum, it allows you to get more oxygen in and you think better. Okay? So, yes.
Does it help to chew with your mouth open?
No, I mean, you're going to be breathing while you do it, but you're just going to be taking more in. So, it's helpful to do that. You obviously, if you're going to chew like a cow, it'll be really loud to the person next to you. Just be prepared to be smacked in the head while you're doing it. And then you just have to say, I deserve that, and move on. So that's why they also say when you're taking any exams, if you put like a couple of pieces of unwrapped candy in your pocket and you have one of those every 30 minutes or hour or something like that, then it can help you kind of get a little boost. It'll pick you up a little bit, okay? So you'll notice I didn't do that in the other 2 sections. Okay. Now, easements. I love me some easements. It falls under the category of servitudes. Why? Because one piece of land is servicing the other, or somebody is having an easement in gross, right? What is an easement? You best have a really good rule for easements, okay? The grant of a non-possessory property interest that entitles its holder to some form of use or enjoyment of another's land, called the servient tenement. In every easement, do you have a servient tenement? Based on that rule, in every easement, do you have a servient tenement?
Yes.
Yes. In every easement, do you have a dominant tenement?
Yes.
Well, think on that for 1 second.
No, I don't know why.
Okay, because you could have an easement in gross,
Oh,
okay?
Yeah.
So you're always gonna have some piece of property that is servicing either another piece of property or a person, but you are not always going to have a dominant tenement. Because if I am given an easement in gross on somebody's land, I don't necessarily have a piece of land I'm coming from, right? Okay, so again, let me say the rule. The grant of a non-possessory property interest that entitles its holder to some use and enjoyment of another's land called the servient tenement. Why do we say a non-possessory interest? Because you are not in possession of it. You just get to use it when they say it's okay. So, now what's the first thing we're gonna do? We're gonna give the rule for easements. Then what are we gonna do? We're gonna start identifying its characteristics, right? What's the first one we're going to identify? Whether it's affirmative or negative, right? So you're going to say easements can be both affirmative or negative. Now, if you find that there is an affirmative easement, at that point, then you put a header for affirmative, right? Am I going to make you go through every single affirmative easement? Maybe, right? As a practical matter on an approach, are you going to go through every affirmative easement? If they're not all present, let me put in that caveat. No, what you're going to do, however, is say there are 4 types of affirmative easements. They are prescriptive, implied, necessity, and grant or express, right? If you're using pine versus pain. That is going to be the extent of you listing all 4 unless they are all 4 present within the fact pattern, okay? But I want you to be able to tell your grader, not only do I see it's an affirmative easement, but there are 4 kinds. Then what are you gonna do? You're gonna put a header underneath there for whichever easement you are identifying. For example, let's say there's a prescriptive easement, okay? You're going to say, easement by prescription is an easement may be acquired by satisfying the elements of adverse possession, right? You guys already know that stuff. That's great, right? But is there any exclusivity required with an easement by adverse possession?
No.
Why? Because they're both occupying the land, right? It does have to be hostile. It doesn't have to be exclusive, okay? So easement by prescription, must be continuous, open and notorious, actual use, hostile without the servient owner's consent. Okay? I just want to note this. Permission defeats the acquisition of an easement by prescription. An easement by prescription requires that the use be hostile. Okay? Now, we have an easement by implication. An easement by implication requires two things, okay? That previous use was apparent and the parties expected that the use would survive division because it's reasonably necessary to the dominant land's use and enjoyment. Okay? Two elements must be readily apparent, or previous use was apparent, and the parties intended or expected that the use would continue. Okay. Necessity. The traditional necessity approach is going to be a landlocked situation, right? That's where we had the big piece of land and the one piece property in the middle, or somewhere within that, right? So the landlocked setting, an easement of right-of-way will be implied by necessity if the grantor conveys a portion of his land with no way out except over part of the grantor's remaining land. Are you required to purchase the helicopter? No, you are not, okay? Now, I don't understand what's happening out there. Okay, so an easement by grant or an express easement is the fourth of this, okay? An easement to endure for more than 1 year must be what?
In writing to
Why?
satisfy the statute of frauds.
Thank you. And it must comply with the formal elements of a deed. Now, am I going to require you to go through the formal elements of a deed? You're like, I hope not, because we haven't done that yet. No, I'm not. I do want you to say that it must comply with the formal elements of a deed. So at this stage of an exam, you would say, for example, in our fact pattern, you would have to say something like, an easement or a grant was provided and it satisfied all the formalities of a valid grant deed. Right? Yes, ma'am, you had a question.
No, you repeated it.
Okay.
So I wanted to Google.
Okay. This is because of the statute of frauds. The writing to evidence the easement is called a deed of easement. Makes sense, right? Must satisfy the elements of a valid deed, and it's for an easement, deed of easement. Okay, those are the affirmative easements. Everybody good with those?
Yeah.
You'll be better at them once you finish studying, I get it. Okay, negative easements, right? Now you are having the use and enjoyment and an affirmative easement to do something. A negative easement is to not do something, okay? The negative easement entitles its holder to prevent the servient landowner from doing something that would otherwise be permissible. Negative easements are generally recognized in only 4 categories. However, in a minority of jurisdictions, they do add a 5th, okay? The 4 are light, air, support, stream water from an artificial flow, and in a minority of jurisdictions, we also have scenic view. Why? Those are really reserved for areas that are like coastal property, mountain view properties, you know, things like that. Or let's say perhaps in New York, if you have, I never thought about this, but this makes total sense. If you are in an area where there's some kind of monument, or in DC, let's say it's adjacent to the Washington Monument, maybe that you can't build up to a certain level and it would affect your view of the property, okay? Negative easements can only be created how?
Expressly.
Expressly, right? By writing signed by the grantor. There is no natural or automatic right to a negative easement. An easement then has its first characteristic again of being affirmative or negative. What is the next characteristic we must identify?
Perpetuate or engross.
A pertinent or engross, okay? There's no other time you're gonna use the term appurtenant. I mean, I could be wrong, but.
There was light air support stream, what would be support?
Lateral or subjacent support,
Oh, okay.
okay? So, now we get into easements that are either affirmative or in gross. Okay,
Permanent?
what's that?
Is it,
Oh, did I say affirmative? Sorry, appurtenant or in gross. When an easement appurtenant requires at least 2 pieces of property, when it benefits its holder in his physical use or enjoyment of his property, it takes 2 parcels of land to be involved. Now, I realize this seems obvious, but these are points you do not want to throw away. When you talk about an easement appurtenant, you must identify that there's a servient tenement and a dominant tenement, and you must tell me which is which, okay? These are easy points you don't want to blow, okay? So, the dominant tenement, the rule that you're going to have for your dominant tenement section, is the piece of land that derives the benefit of the easement. The servient tenement is the one which bears the burden of the easement. Everybody good with that? Okay. That's an easement appurtenant. You must have at least 2 parcels of land. Now, can you have more than 2 parcels of land with an easement appurtenant? Let me give you an example. I guess the answer is yes then if I'm giving you an example, huh? All right. My mountains that look like waves, right? Mountains. Road. Okay. That goes bad. Okay, so we have 1 piece of land here. Okay. If going through parcel C is the only way to get to the road, can you have an easement appurtenant with more than 1 piece of property? Effectively, yes, but what are you really looking at? You're looking at B and C having their own easement, right? Because B's got to get off of the land to the road. B doesn't require any more than 2 properties to be involved in that, right? So between this is going to be the dominant tenement, and C is going to be the servient tenement. A would likely, though, have to have 2 easements, right? One between A and B to go through B's property, and then moving into C. So we've got an easement appurtenant, they're now the dominant tenement.
And then C and C both serving it.
And to A, these are both going to be servient tenements. Does that make sense?
so you would analyze them as 2 separate easements?
I would.
Okay.
Yes, because A doesn't have anything to do with the B and C easement, do they?
No,
No.
I meant like A and B, and then you do A and C.
Yeah.
Okay.
I mean, well, I don't know that you necessarily have to do them separately. They would be the same easement or the same requirement. That would be an easement by necessity, wouldn't it?
Mm-hmm.
And it would be an easement that A holds with both parcel B and parcel C, because there is no way for A to get to the road without traveling through both B and C. You can analyze them together because they have the exact same facts, right? But B cannot be analyzed the same way necessarily as A, okay? Does that make sense to everybody?
Mm-hmm.
So you can have multiple easements appurtenant that come in the same fact pattern. Yes, ma'am.
But wouldn't B also be not by necessity?
Yes,
Oh, okay.
they just only have 1 servient tenement to go through.
Okay.
A is gonna have 2 servient tenements to go through. Just like erase everything. No. Okay. Undo, 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 undo. No, that's gonna take way too long. Okay. I don't feel shaky, which means I didn't work out hard enough. I'm way too easy to erase all of this. In the middle of my class today, a gentleman who appeared to be suffering from some kind of degenerative mental disorder walked into the class and just was chatting it up with the girl in the front trying to walk through the middle of the class, and we were like, somebody lost him. It was very sad for a second, but at first I was a little concerned he was just trying to like steamroll through, and then I realized that maybe he just didn't know where he was. Okay, so now we've got the easement appurtenant, right? And then we've got an easement in gross. So the easement in gross is only going to require one parcel of land. If it confers upon its holder only some personal or pecuniary advantage that is not related to his or her use and enjoyment of the land, here a servient land is burdened. However, there is no benefited or dominant tenement. Okay, let's talk about the transferabilities of easements, okay? An appurtenant easement passes automatically with the dominant tenement, regardless of whether it's even mentioned in the conveyance. The burden of the easement appurtenant also passes automatically with the servient estate unless the new owner is a bona fide purchaser without notice. Okay, so dominant, it automatically transfers. The servient is only burdened if they had notice. If they don't, then they can't be a bona fide purchaser. Bona fide purchaser is going to be exempt from that passing, okay? An easement in gross is not transferable unless what?
Commercial purposes.
Unless it's for commercial purposes. All right, I did forget one thing that you guys need to be very cautious of. Remember I told you talking about an easement is like telling a story from beginning to end. What do we start with? Creation. Okay? You have to tell me how to create an easement. So you're going to give me the rule of an easement, then you're going to say create, then that's where we're going to get into the identifying characteristics, affirmative or negative, appurtenant or in gross. Okay? Then what are you going to get into? The scope, right? So it's going to be 1, creation, 2, scope. It's a 3-step story, 3-chapter story for every easement, okay? Well, a maximum of a 3-chapter state or 3-chapter story. So now we get into scope. The scope of an easement is determined by the terms and conditions that it created. Okay? So what are you most often going to do here?
What's the language?
You're going to give me the language. You're literally going to write the language of the easement on your page under scope. Okay? Unless there is some issue of scope or exceeding the scope, there really is no further discussion. Okay? I gave you the example of like a private home and there was this easement so that they could use a road. By the way, chances are if you get an easement question, you're going to need to draw it out. Okay? Please do not forget to do that first. Do your outline. It is critical that you outline your questions, especially with the number of parties that could be involved, the number of easements that could be involved, okay? So, under scope, unless they exceed the scope of the easement, scope is not really going to be a significant discussion. If they do exceed, then you can talk about that. But don't miss scope because it's easy points, okay? They're points you would be literally throwing away, okay? Now, after scope, we get into our third section. What's the third section? Termination of an easement, right? There are a number of ways you can terminate an easement. The first of which is estoppel. The servient owner, oh, by the way, this is where I feel like you can get really jazzy. If you say there are a number of ways to terminate an easement, including estoppel, necessity, destruction of the servient tenement, condemnation of the servient tenement, release, abandonment, merger, or prescription. And then you head note the ones that are present or the one that is present. That to me would be a much more complete way to manage that. Why? Because then I know you know all the ways that this could terminate and you can reasonably identify the one that's present. Okay?
Do you want us to give head notes for each and then the,
No.
like the rule?
Nope.
Of each one, no?
I want you to do exactly what you would do with affirmative easements. There are 4 types of affirmative easements. Prescriptive, implied, necessity, grant. Then give me a head note for the ones that are there.
Okay.
Same thing for this, okay? You do not have to spend the time giving me for rules about a bunch of things that aren't present, okay? All right, estoppel. The servient owner materially changes his or her position in reasonable reliance of the easement holder's assurance that the easement will not be enforceable. Okay. Necessity. This is an easy one. What happens to the necessity? It stops existing, right? Remember I told you they blew a hole through that mountain, they built a tunnel, you can now get off your property, right? Now, what if it collapses? Can you just say the necessity is back? No, you got to go back to the top and start with creation of an easement. And then say, once the tunnel collapsed, there was no way for them to get out reasonably, there's a new easement by necessity. Talk about the scope, because now it's just not, there's a mountain range there. It's a mountain range where there was once a tunnel, now that thoroughfare has collapsed and is no longer allowing access. Now, what you might want to also say, let's say there's a mountain range behind you or some hills or something. Are you going to reasonably require somebody to travel for hours or days over the mountain range or hills? They could technically get through there, right? But that's not reasonable, okay? So, effectively, when the necessity ends, the easement ends, it terminates, okay? Now, let me give you a little trick here. What if the easement by necessity was also drawn up in an easement, an express easement, or an easement by grant? Does it automatically terminate when the easement or when the necessity ends? Anybody? Let me give you this hypothetical again. We created both an easement by necessity, because let's say these people are landlocked, but they also drew up an easement by grant. Necessity ends. Does the easement end? No. Because you still have an easement by grant, right? Okay. Should make sure you guys know that. All right, the next one is destruction of the servient tenement. Let's say, and I think I used the example following that horrific fire that we had in California, if the land is completely destroyed, and let's say there's trees that fell down everywhere, doesn't that terminate by destruction of the servient tenement? You can't get through the property anymore, right? Now, what's the exception? It's destruction of the servient tenement as long as it's other than through the willful conduct of the servient owner. Okay?
Wait, what's the exception?
As long as it's done not by the willful conduct of the servient owner. Okay? Now we get into condemnation of the servient estate. This is different, though I realize it seems similar to destruction of the servient tenement. Condemnation of the servient tenement or servient estate is really an issue of eminent domain. So eminent domain will end an easement. So if the government comes in and takes over the property, it is condemnation of the servient estate. Who do you think is going to win in that? Government, right?
Government, man.
Yeah, but do they have to compensate you for the loss of the easement? The answer is Yes, they do.
because it's taking. We'll get into that a little bit more later on.
Yeah, like next semester.
So the next one's going to be release. Let me be very clear. This is a written release given by an easement holder to the servient owner. Okay? That's a pretty easy one. Now it's not written. Is it going to be a valid release? No. Then we've got abandonment. The easement holder must demonstrate by physical action the intent to never use the easement again. Abandonment requires physical action by the easement holder. Now, what could we reasonably do? What if they put up a fence in the way? Wouldn't that make sense?
Yeah.
What if in the roadway that they used to use, they built or they grew crops? Okay? All right, now I love this one, the merger doctrine. Okay? This one's kind of fun. So, merger doctrine, the rationale here is I don't have to ask myself for permission to use my own land. Okay? So, if an easement terminates by way of merger, then the title of both properties are shared in the same person. The easement is extinguished when the title to the easement and title to the servient land become vested in the same person. Now let's say I have both properties, A and B, and I decide to sell B to Professor Drucker. Does it by its very nature create a new easement? Let's say there was a grant easement. Does it automatically start again now? No. You have to start and create a whole new easement. Okay? It doesn't just become a zombie, right? All right. The last one is by prescription. The servient owner may extinguish the easement by interfering with it in accordance with the elements of adverse possession. Same elements as before. If complete unity of title is achieved, the easement is extinguished, even though there may be later separation of the title of the easement is not revived. That's really more of a merger description. Okay, that's easements. Okay, you start with the rule for easement. You identify its characteristics under creation. Okay, so you create the easement. Give me the rule to the easement, then you create it. Is it affirmative or negative? Then is it appurtenant or engross? Then you're going to identify the scope of the easement. But before we get there, we're going to say how many types of affirmative easements do we have? 4, prescriptive, implied, necessity, and grant or express. How many negative easements do we have? Depends on which jurisdiction you're in, right? In a majority of jurisdictions, we have 4, light, air, support, stream water from an artificial flow. In a minority, we add a 5th for scenic view. Then you get to whether it's appurtenant or engross, which requires at least 2 parcels of land. Appurtenant. Can engross be transferred? Unless it's for commercial purpose. Can a appurtenant easement be transferred? Yes. Which one does it automatically pass with?
Dominant.
The dominant tenement. When does it pass with the servient tenement?
Bona fide purchaser.
When you have a bona fide purchaser, or it will not pass if you have a bona fide purchaser. Okay? It will pass unless there is a bona fide purchaser. Okay? Then you get into scope. Scope is not an issue unless what? They exceed the scope. Otherwise, give me the language of the easement and move on. Then we get into yes, sir.
When we talked about bona fide purchaser, didn't we say there was an argument that it's hard to be a bona fide purchaser because you have notice and something else, or was that
Well, it's hard to be a bona fide purchaser because you'd probably fall into one of the 3 categories of notice.
Right. Okay.
Why? Because record notice may show in title searches the previous conveyance of the
Which
easement,
will include the easement, okay.
right?
Right.
If it doesn't, and let's say there was a road, but there's brush that's covering it now, and it was kind of like not a gravel road, but like a dirt road. You may not be an actual notice because nobody may have told you, you may not have seen it. Maybe no inquiry notice because you wouldn't have known otherwise to ask or be of note.
So
And then
more than
record,
likely-
let's say it's not in there any longer.
More than likely though, it's gonna be not going to be a bona fide purchaser because they had.
Chances are it's not gonna be a bona fide purchaser.
Okay.
So then after scope, we get into termination, right? What did I say about termination? I'd like to know that you know all the types of ways to terminate it, but I don't need you to describe each one of them unless they are present. So we've got estoppel, we've got necessity, we've got destruction of the servient tenement, we've got condemnation of the servient tenement, we have release, we have abandonment, we have merger, and we have prescription, okay? That is easement. Now, if an easement ends and a new one begins, you best believe you gotta tell a new story, all 3 chapters, unless there's still one outstanding, right? Let's say there's some easement, it's ended, a new one has started, and then you show the scope, but there's been no termination. Then you say, there's been no termination of this easement. It continues. Okay?
I have one question. For
Yes.
prescription, when terminating an easement, can you just go over that one more time?
Sure, the servient owner may extinguish the easement by interfering with it in accordance with the elements of adverse possession.
Thank you.
All right, what walks hand in hand with every easement? License, okay? Profit doesn't, but it's related.
I was gonna say privilege.
Oh, privilege. No,
That's not.
no. So license does, because if you find that it's not a righteous easement, it defaults to a license, because a license is a mere privilege to enter another's land for some delineated purpose. If you get an easement question and you do not write on license, you are throwing points down the toilet. Okay? A mere privilege to enter another's land for some delineated purpose. Are licenses subject to the statute of frauds? No.
Why
You
is
don't.
that, by the way? Why is that as a matter of law, by the way? Anyone know? It's only funny because I used to work in the music industry. Actually, it's the only reason I know. I didn't even know this from real property. Anyone know? Because licenses actually don't rise to the level of a contract. Therefore, they're not subject to contract law. That's the actual answer. They're for a limited time, for a limited purpose. But they don't rise to the level of a contract. How about that?
So that being said, licenses are freely revocable at the will of the licensor, so the person making the license, unless what?
Estoppel.
Unless estoppel applies to bar revocation. Estoppel will apply to bar revocation only when the licensee has invested substantial money or labor or both in reliance on the licensee's, on the license's continuation. Okay, you remember the well case? All the labor and money, it was like what, $7,000, but back in the day, it was significant, right? It got done and he said, thanks for your help. License is terminated. Revoking it. Traditional license cases include tickets. Tickets create revocable licenses. Next time you go to the movies, read the back of your ticket. Notice it is a license. Okay? Neighbors talking by the fence are another traditional one. An oral easement is unenforceable because it violates the statute of frauds. An oral agreement instead creates a freely revocable license. Okay? Now, a related issue, but one that should not be discussed unless the facts are present, is profits. The profit entitles its holder to enter the servient land and take from it the soil or substance of the soil, like minerals, timber, oil. It shares all the risks of an easement. Okay? That's why I say it's related, but it is not going to walk hand in hand.
That's great. Oh, let me show you something real quick. Why it is in the easement section though. Just so, because it's, here is, right, here's your land, right? And in the middle of the land is say a gravel pit. Okay, and so you grant a profit to gravel company, right? Then you say, you say, let's say that you wrote out a contract that said you are entitled to take out so much gravel a year. Okay, and that's basically what it says, for this much money. Okay, so it's a real deal, right? Even given those facts, as I just told you, you wrote that on a napkin, what's missing? If you think about it as a practical matter, what's missing? I didn't give you the right to come onto my land to get the gravel. I just told you you can get 50,000 pounds of gravel a year from this thing during the year 19 something like that. I don't actually mention the easement, right? In a profit, because it is a term of art, you don't have to. The easement comes along as part of it. That's why it's in the easement section. That also speaks to what you were saying, believe it or not. That's why I thought about that, because every profit, whether an easement is mentioned or not, comes with an implied easement. And that's why it makes this section of your book. Got it? Okay, so that's actually the reason why. Change for two. I mean, yeah, you can take the gravel out, but don't you dare come on my land. That doesn't. That will default to a profit if somebody does that, because it's for a commercial venture. Yeah. All right, just so you know.
All right, so now we get into covenants and equitable servitude. So we're in the home stretch, folks, okay? Right? Yay, everybody pick up, suck back some more of that coffee, get some more water, take a stretch if you need it. A little Diet Dr. Pepper over there, do your thing. Okay. Covenant, equitable servitudes. How do we distinguish which you should be using in your response or approach to an exam question?
Whether you're seeking monetary damages or injunctive relief.
Right, so you're looking at what type of relief or remedy is being sought, right? Determine whether it's a covenant or an equitable servitude based on the remedy plaintiff is seeking. If they are seeking money damages, what approach are you using?
Covenant.
Right, if they are seeking injunctive relief, equitable servitudes, right? Because money damages are restitutionary remedies. Equitable servitudes, right, are equitable remedies, okay? So the covenant is a promise to do something or not do something related to the land. It's not a promise to the other, a personal promise to one another, to do something, that way. It's to the land. It's unlike an easement because it's not the grant of a property interest, but rather a contractual limitation or promise regarding the land. Okay? You're not allowing somebody to use your land. You're promising that you would do something with your land or not do something with your land. Okay? So there's really no I suppose there's really no righteous, dominant, or servient tenement there. So, can covenants be both affirmative or negative? Yes. Covenants can be negative or restrictive covenants when they are a promise to refrain from doing something related to the land. So identify that. Identify whether or not it's an affirmative or negative. Covenants can be affirmative. The affirmative covenant is a promise to do something related to the land. Okay, we burned through that page, and I want to tell you that's a good thing because I realized I was missing a page of notes and I found them. My apologies, 10 pages. It's really like 9 1/3, okay? So everybody's fine. Everybody's fine. All right. Now, what do we ask ourselves when approaching a covenants question?
Does it run with the land?
Will the covenant run with the land? And how do we identify if the covenant's going to run with the land? What does it mean if the covenant's going to run with the land as a practical matter?
If the burden runs.
Well, we're talking about whether or not it's going to bind its successors, okay? And the first thing you're going to do, are you going to do burden or benefit first?
Burden.
Why?
Because all the elements of benefit are within burden.
Exactly. What other elements are contained?
Writing, intent, tension, concern, horizontal and vertical privity.
And notice.
And
That wasn't my question though, but that was a good answer. My question was related to the fact that if you were to get a question like this and you weren't told what remedy was being sought, all of the elements of equitable servitude are also contained within the elements of burden, okay? That's why we start with burden first. And if you weren't given the type of remedy sought, would you start first then, and I think you guys know the answer to this, would you start first with a covenant or an equitable servitude?
covenant.
Covenant, absolutely, right? Because all of the elements of equitable servitudes are contained within the covenants, and so it's better to do it that way than to start building up, okay? So, the equitable servitude, in order to create an equitable servitude that will bind its successors, one must show writing, generally but not always the original promise was in writing. I'm sorry, hold on. No. Original promise between A and B must have been in writing. Intent, the original parties intended the covenant would run. And courts are pretty generous in finding this, okay? Touch and concern the land. The promise must affect the parties' legal relations as landowners and not simply as members of the community at large. Covenants to pay money used in connection with the land, such as homeowners association fees, and covenants not to compete do not touch and concern the land. Okay? So those are not covenants that touch and concern the land. Then we have horizontal and vertical privity. Horizontal privity is a nexus between the original parties. Okay? This requires that they be in succession of estate, meaning that they were in a grantor-grantee, landlord-tenant, or mortgagor-mortgagee relationship. Vertical privity refers to the nexus between A and A1. It simply requires some non-hostile nexus, such as contract, a devise, or a descent. Now, I want to be clear. I say A and A1 because when we're talking about the burden, this is for effectively for the servient tenement, right? This is for the burdened parcel of land. Does that make sense? Does that make sense?
Kind
Okay, well, A and A1 are going to be burdened. When we're talking about the benefit, then it's going to go B and B1. Okay, I'm just saying, you have to pick a side. So, the only time vertical privity is absent is when? If I said it has to be a non-hostile nexus, when is the only time when vertical privity would not be present?
When it's adversely possessed.
when it's an adverse possession issue. Okay, that is burden. Now we're going to ask, does the benefit of A's promise to B run from B to B1? That is the benefited party. You must show writing, so the original promise between A and B was in writing. The intent, original parties A and B intended that the benefit would run. It touching concerns the land, promise affects the parties as landowners, not as general members of the community at large. And vertical privity only. Non-hostile nexus between B and B1. Horizontal privity is not required, okay? Now, if you show that both the burden and benefit run with the land, then the covenant will run with the land, therefore it is capable of binding successors. So your conclusion would then say, if it wasn't, let's say for example, the benefit did not, or the burden did not run with the land, therefore it cannot, the covenant cannot bind successors in interest, or is not capable of binding successors. Now, transitioning from covenants, which you approach when you were seeking money damages, let's talk about equitable servitudes. The equitable servitude is a promise that equity will enforce against successors. It's accompanied by injunctive relief, right? To create an equitable servitude that will bind successors, one must show a writing, intent, touching concern, and notice. So generally, but not always, the original promise was in writing. The parties intended that the promise would bind successors. The promise affects parties as landowners, and successors of burdened land had notice of the promise. Privity is not required to bind successors. That is the difference between a covenant and equitable servitude, aside from the approach of what type of damages are being sought, or what type of remedy is being sought. Yes.
I have ES as some of the elements, but I don't have any notes. There
It just
isn't.
stands for equitable servitude.
Oh, so it's not part of. the
Writing
elements.
intent, touching concern, notice, and then that's just how you identify it.
Okay.
It's easy to remember too.
Okay.
Yes,
So it spells witness.
Yes.
That sort of.
precisely. All right, that is equitable servitude. Same elements, effectively the same discussion.
Sorry, you said the only difference aside from the injunctive relief and monetary damages is that privity is not required. in
Privity is not required to bind successors
To bind
in
successors.
equitable servitude. It's not one of the elements. Not vertical, not horizontal, not both. Okay? Now, subcategory of equitable servitudes, the implied equitable servitude. Okay? This is what we call a general or common scheme doctrine. Just think gated community, right? So there are two elements to a common scheme doctrine. When the sale began, the subdivider, right? So let's say, I think in my example, I use Beezer Homes, right? So Beezer Homes is a subdivider. The first element is they had a general scheme of residential development that included the defendant's lot. So out of the 10 lots that this developer was breaking down into a subdivision, the defendant's lot was contained in that original subdivision. And the defendant lot holder had notice of the promise contained in the prior deeds. Okay? Now, there are three forms of notice, right? Actual, inquiry, and record. Actual meaning that defendant had literal knowledge of the promise in the prior deeds. Inquiry meaning neighborhood conforms to the common restriction. You can look down the street and see what it looks like, right? You can see that every person has the same kind of garage door, or that everybody is part of the same palette in terms of color. Record notice, meaning that the form of notice sometimes imputed to buyers on the basis of the public document. Now there's a split of authority on this. Some take the view that subsequent buyer is on record notice of the covenants of prior deeds transferred other than the common grantor, or to others by the common grantor. What does that mean? That means you have to be on notice of all, or you have record notice of all of those 10 pieces of land that were conveyed by the same subdivider. The better view and the majority of jurisdictions say you only have to do the title search for your piece of property, right? Now, think of how cumbersome that could be if you have 147 lots in your subdivision, right? Not reasonable. And would probably be incredibly expensive to do title search on every single one of those. You're pricing people out here, okay? So, what is the one exception to the common scheme doctrine?
Change conditions.
Change conditions, right? The changed circumstances alleged by the party seeking release from the term of an equitable servitude must be so pervasive that the entire area has changed. It's never sufficient to just use mere pockets of limited change. So like I said, when they had the garage door suggestion, right? Or let's say there's new stucco being used because, oh, here's the better option. Lead paint, right? Well, they don't use it anymore. Let's say instead the stucco isn't produced anymore. Are you gonna be required to use that? No. It's gonna kind of phase in to the point that it's so significant, right? It's so pervasive that they're not just mere pockets of change. Yes.
Was the global warming one a defense as well? Like when we started going, or not global warming, the drought?
Well, I started talking about the, well, that comes into another issue, but sure, when people started transitioning into desert landscape, maybe only one person had it, and before it was required that you had 2 trees and a certain amount of lawn and whatever. Now, let's say that just became the style.
Mm-hmm.
If 1 or 2 people in the community have it, you're probably not gonna be able to do that. Now, leaving the drought out, okay?
Mm-hmm.
Now, if 60% of the community has it, do you think that you're gonna have a better argument? Absolutely. Now, the drought kind of is the clincher because at that point, there was legislation that said you cannot require people to put in things that will require more water, okay? But what you could require them to do was keep everything looking tidy. So if they had a dead tree in their lawn, they had to go take it out. And you couldn't do that. You couldn't require them to replace it, however.
Yeah, and think about, again, solar panels too.
Yep.
No longer can homeowners associations ban people from using solar panels. That's just California law. They can't do it. So.
You'll notice I'm putting away my outline. Does anybody have any questions? What's on the, I know, every year I do it. It's a good effort. Which one? Okay, so let me just say, be prepared, it will be challenging. Okay? Everything you have going on this Saturday is going to be challenging. Real property is going to be particularly challenging. However, start from the beginning, go through, outline. Before you outline, you're going to need to draw out your exams. Okay? Please, do not try to rush into typing something up. Please. All right, any questions? None that your brain will allow you to form at this point of the evening, right? Okay. You guys are gonna do great. We have every bit of confidence in you. And I am also taking into consideration that the exam and or exams are quite challenging. Okay? Let me just give you fair warning. Do not go over the hour for any one of your exams this weekend. The extra couple of points or 5 points that you get on the exam is not going to be worth the 15 that you lose on your last question. Okay?
That would be a good lesson to learn this year, because you won't, if you do it next year, even worse.
But what happens is a practical matter. You take an extra 5 minutes from the first question, or for the first question, then maybe like an extra 5 for the second. Oh God, that third one was really hard, so I'm gonna have to take 10 for that one. By the end of it, you've got 40 minutes to answer your last question. Do you want to run into a really burly real property question with 40 minutes to do it? The answer is absolutely hell no. Okay? So please, I know it pains you to do it. It pains me to do it when I take exams. Move on in an hour. If you have time at the end, great, go back and fix it. Okay? Do not keep going. Just move on to the next. Okay? Promise? Everybody? Promise? Blood oath? All right.
Everybody, air pinky swear.
Just so you know, we were gonna just let you all have a pass if you had worn that Efron beanie, but
Why is it from being?
I don't know, I just love it. It just makes me happy.
What do you call it, an Efron?
Zac Efron.
Zac Efron.
He used to wear like the beanie with like the bangs on the front, and I just think it's so cute. All right, everybody, good luck. You guys are gonna do wonderful. You're halfway done with real property.
Not yet.
All right, what do you take? Jeez, Downer. I'm trying to be positive for you.
Alright.
It's still moving over.
Yeah, I was actually thinking of getting a blue.
A blue one?
But might not now because of it.
Well, I mean, blue's fine too. I like me some blue,
Listen,
but
the light gray is plastic.
Yeah.
he had a green one.
Yeah, he had like a
Yeah.
horse screen.
Well, then get a light gray one. Light gray is plastic.
Have a good night, everybody.
Good night.
You guys are gonna do it.
Oh, wow. Oh, jeez. What are these? For sure. Is there a Saturday as well? Are you here on Saturday as well? Like, no, you can help
I'll be in the afternoon. Well, I'll be in the afternoon, but I might
I'm not.
have to
Oh.
do it in the morning.
I know.
Somebody that's honestly, he's fine, just let me know.
It's on more time. Right.
Yeah, so I mean, I'm up anyway. That's the weird part. Oh,
I don't know.
I'm up anyway.
That's what come to my second husband.
It's gonna suck though because that shit's gonna be all over the multi-states.
Yeah.
And there's so many rules.
You guys need something too.
Yes.
Mm-hmm.
Killing me, these people are killing me.
Your source needs to be fired.
I know.
Or just one really hard. Yeah, that covers everything.
There's no way, you can't do easements,
No.
cause you would have multiple easements, she said that, you're gonna have multiple easements, right? That you have to draw out. There's no way she's gonna do.
Yeah, there's no way
Well,
you.
we did a covenants and equitable servitudes question over the weekend, and there's no way you can get that and easements done in an hour, there's no way.
Yeah.
But, I don't know. Maybe it's
If we
what the-
get 11 today, I'm just
No, then we I feel like
Yes, I-
most of that stuff, I feel like we were going over there for the first time, I was like, I don't remember any of this.
Yeah, well, it seems so, cause I think it's because they think it's easier, so they just don't.
When she was in here.
That's right,
So a lot of
that's right.
times we don't like, oh, I have these now.
That's right.
Yeah, well, because really when we went with Drucker, we were just going over the cases,
Right,
you know?
that's right.
Not doing like what she does with their outlines, but there's so many rules for land, duties of the landlord, duties of the tenant, it's ridiculous. It's gonna be all over the multi-state stuff.
I mean, it sounds like she knows we're not gonna have time, doesn't she sound like she said that, like, well, basically, I know you're gonna have time to finish it, so just move on.
So basically, no one scores super high, so we can all get a good score.
Yeah.
Right?
Well, do you think it's gonna be broken up into two different essays? One on easements and one on covenants and equitable servitude?
That's what
I don't think it's as hard as what we had as an essay. That was as if we were like
Over the weekend?
super, yeah, that was like
That was just covenants.
so much.
That was just straight covenants.
That was straight up covenants and equitable servitude.
Yeah.
Yeah, that'd be one.
That was just
That
one.
is probably what we're gonna get,
Probably we're gonna get for one essay, but then the other one would be easements.
Yeah, that's what I would think. I would think,
with multiple easements.
It's gonna be brutal, but I think she said your essays are gonna be hard, real hard, it's gonna be particularly hard.
so
Kind of
that
implying,
particularly hard.
like, that's what I took it as, like implying that there's gonna be two.
She
Other
probably
than-
doesn't like both. And I think with, I think like how we saw in, our evidence question, they can fit one into one question.
Oh my god, I know.
So there's, so they could test us on,
Question.
they could test us on everything they want to in one essay.
Dude, that evidence essay, no way I'm finishing that in an hour, no
And wonder
way.
if they squawked. I mean, you know what I'm saying? It's like, it's like almost 2 pages of reading. Let alone that.
Well, each question had like 5 questions.
Well, that's what I don't like about it, you don't
Five
really
questions in one.
use the facts before the questions in the essay for evidence. Like, you don't really go back to that and use that. You use the facts that are presented
In the
in the
question.
question.
Yeah.
In the question, it's not like, I don't know, weird. And then Civ Pro's gonna be a fucking pain in the ass.
You guys even go over a thing? I didn't
haven't
know
done
In
that.
Civ Pro,
anything in Civ
no,
Pro.
I haven't done anything yet.
And I think that's when I struggle.
Hmm?
Like struggle the most, but I'm not even like thinking about Civ Pro right now,
You want
because there's so much to
evidence.
do.
God, imagine if it was like, because I mean, at least these approaches for covenants and equitable servitude, you can like,
Yeah, they're pretty
Understand.
straightforward.
They're
Yeah,
pretty
we can
straightforward.
memorize them,
Right.
and we know.
Imagine if it
They
was
put,
like- imagine if it was future interest and landlord tenant.
What?
Imagine if
Oh
it was
my
like
God.
future interest and landlord tenant.
I feel like I
Yeah,
was.
because you want future interest. I was like, because future interest, we got that before the midterm. That was not an after midterm.
No, yeah, it's not.
So when he said that, I was like, wait a minute. I was, that was after, that was before.
Yeah, I think we're just telling us that, and then to prepare us that we were probably gonna get a hard class, it was one of the hardest classes, including.
Oh,